This is Devin DeVore from McKellar and Easter, and the question I get from many clients after I help them with filing for benefits is, well, what happens next? And so in this video, I want to briefly review each stage that your case may go through after you file your claim for disability benefits. Once you submit your application, your case is going to be sent to a state agency called DDS. Each state has their own DDS office, and once it gets there, it's going to be assigned to a disability examiner who's going to request your medical records and send you paperwork to complete regarding your daily activities and your work history. Once they receive your medical records and that paperwork, they are then going to send it to a physician who's contracted with the state, who's going to review your file and issue a decision. If you're approved, then great. If you are denied, you'll need to make sure to file an appeal within 60 days of the denial date. Do not file a new application. You can file an appeal by going to ssa.gov. You can also file a paper appeal by sending it to your local Social Security office, but I would highly advise against that because you run the risk of having the appeal lost or misplaced. After you file the appeal, your case is going to be sent back to DDS, who's going to assign it to a different disability examiner who is going to request your medical records for any treatment you received since you first filed your claim, as well as send you paperwork again regarding your daily activities to determine how your condition has changed since you first filed. Once they receive your updated medical records as well as that paperwork, they're going to again send it to a physician who's contracted by the state who review your claim and issue a decision. If you're denied a second time, you will still need to file an appeal within that 60 days of the denial date in order to take your case to the next step. Once you submit the second appeal, your case will then be sent over to the Office of Hearing Operations where it will be scheduled for a hearing. Now it's going to sit there for a little bit, but once your case is organized and assigned to a judge, it will then be scheduled. And it is important to know at this stage that it will be your responsibility to submit any and all medical records that are not already in your file, and they'll need to be submitted no later than 5 business days before your hearing. The hearing itself is actually rather informal. The only people that will be there will be the judge, you, a court reporter, a vocational expert, and your attorney if you have one, and the judge will ask you questions regarding your disability. And your attorney can also ask questions as well if you have an attorney present. Once you provide your testimony, the judge will then go to the vocational expert who will classify your past work and then render an opinion as to whether there's any jobs that you can perform based upon various hypothetical questions that the judge or your attorney may ask regarding various limitations that you may have as supported by your medical records. After your testimony, the judge will then review your file, review your testimony, and issue a written decision. Very rarely will a judge actually make a decision right there at the hearing. If the judge approves your case, then your benefits can start. If the judge denies your case, you will then need to file another appeal within 60 days of the denial date. At this stage, your case will be sent to the Appeals Council, who will determine whether the judge made any errors of law or fact when deciding your case. Therefore, generally no new evidence will be submitted. Now, there's various outcomes that can occur here. For example, the Appeals Council will decide either that the judge was correct in finding you not to be disabled, or that the judge did make errors of law or fact and therefore remand it back to the judge for another hearing, or they can reverse the judge's decision and find you to be disabled and approved for disability benefits. That said, the last scenario is pretty rare. If you disagree with the Appeals Council decision because they denied you, you have the option to file a civil action in federal district court by filing a complaint. And this complaint must be filed within 60 days after the Appeals Council decision. You can also file a new claim and file a new civil action at the same time. As you can see, the disability process can be quite confusing and complex. And so if you have any questions, feel free to call me at 865-566-0125. You may also visit my website at www.helpingclients.com, and on there you can find my ebook that you can download for free.